Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for joining us for this post-argument episode of SCOTUScast, Map Drawing and Partisan Gerrymandering Edition. I'm your host, Bridget Flaherty. On March 26, 2019, the Supreme Court heard argument in Rucho v. Common Cause and Benisek v. Lamone, two cases involving gerrymandering. We will discuss both arguments in this episode. Rucho v. Common Cause involves whether North Carolina's 2016 congressional map involves unconstitutional gerrymandering in violation of the Equal Protection Clause of the 14th Amendment, the First Amendment, and Article 1 of the Constitution. In March 2017, a three-judge district court ruled that North Carolina's 2016 Congressional Redistricting Plan constituted unconstitutional gerrymandering because the state General Assembly improperly relied on political data to draw districts to increase the number of Republicans in North Carolina's congressional delegation. The court ordered new maps to be drawn for use in future elections. Following the court's instructions, the General Assembly drew a new congressional district plan according to criteria identified by the Joint Select Committee on Redistricting. One such criterion was partisan advantage, which, relying on population data and political data, would make reasonable efforts to construct districts in the 2016 plan to maintain current partisan makeup of North Carolina's congressional delegation. The plan was approved by the committee, the North Carolina Senate, and North Carolina House of Representatives, all along party lines. Others filed objections to the plan and asked that the court reject it as partisan gerrymandering. The court held that the plan constituted unconstitutional partisan gerrymandering and enjoined North Carolina from using the plan in any election after November 6, 2018, and directed the parties to submit briefs relating to whether the court should allow the plan to be used in the 2018 election and allow the General Assembly a third opportunity to draw a plan. Although the U.S. Supreme Court vacated the district court judgment and remanded the case for reconsideration in light of its 2018 decision in Gill v. Whitford on standing, the district court subsequently concluded that the plaintiffs had standing and reasserted its earlier determination on the merits. In August 2018, the district court concluded that there was not enough time to review a new plan before the seating of the new Congress in 2019, as well as determined that a new schedule for elections would interfere with North Carolina's electoral machinery. Thus, the court declined to enjoin use of the plan in the November 2018 election. The Supreme Court thereafter granted certiorari to consider 1. Whether plaintiffs have standing to press their partisan gerrymandering claims, 2. Whether plaintiffs' partisan gerrymandering claims are justiciable, and 3. Whether North Carolina's 2016 congressional map is, in fact, an unconstitutional partisan gerrymander. Lamone v. Benisek involves Maryland's 2011 redistricting plan, particularly whether the state redrew the boundary of one district to burden Republicans. Following the 2016 census, Maryland redrew the lines of its congressional districts and state legislative districts. The 6th congressional district had grown by approximately 10,000 residents, which required adjustment of the district boundaries. If only a slight adjustment for population had been applied, the district would have been unquestionably Republican. Instead of this slight adjustment, the plan swapped half the population of the former 6th district with about 24,000 voters. The change created, in effect, a difference in 90,000 Democratic votes. Plaintiffs argued that in enacting the 2011 law, the state deliberately diluted Republican votes in violation of the First Amendment. A three-judge district court agreed with the plaintiffs, enjoining the state for using the 2011 Congressional Redistricting Plan after the 2018 congressional election, and requiring it promptly to adopt a new plan for use in the 2020 congressional elections. The Supreme Court granted certiorari to consider 1. Whether the various legal claims articulated by the three-judge district court are unmanageable, 2. Whether the three-judge district court erred when, in granting plaintiffs' motion for summary judgment, it resolved disputes of material fact as to multiple elements of plaintiffs' claims, failed to view the evidence in the light most favorable to the non-moving party, and treated as undisputed evidence that is the subject of still unresolved hearsay and other evidentiary objections. And 3. Whether the three-judge district court abused its discretion in entering an injunction despite the plaintiff's years-long delay in seeking injunctive relief, rendering the remedy applicable to at most one election before the next decennial census necessitates another redistricting. And now, to discuss the cases, we have Derek Muller, Associate Professor at Pepperdine University School of Law.
The Supreme Court has been asked once again to wade into the political thicket and determine whether or not there is a justiciable standard for the federal courts to patrol whether or not redistricting, whether it's congressional redistricting or state legislatures being redistricted, have been excessively partisan gerrymandered. That is, have the legislatures, when drawing these districts, drawn them in such a way that sort of unjustifiably entrenches themselves or their own party interests at the expense of voters and their opportunity to maybe win more seats or perhaps even gain control of the legislature in the state house or to gain additional seats in the congressional legislature. So this has been a long-standing question in the federal courts for some time. Gerrymandering is obviously a very old problem. It extends back to the founding of the Republic. There's lots of incidents of the founders sort of gerrymandering and trying to throw out individuals they don't like, drawing them out of districts and so on. But, in recent years, particularly as we've moved past one person, one vote, we've required pretty consistent redistricting, equal numbers of people in districts, redistricting every 10 years in all of the legislatures in the country. We moved in a direction where this has become an increased problem for many, particularly given that we have computerized maps and the ability with some pinpoint accuracy to draw districts in such a way to entrench one party over the other. So this has been a question of political scientists for some time, a question the court has been asked to address since 1986. The Supreme Court, in a case called Davis versus Bandemer, said, yeah, absolutely, the federal courts are open to hear these kinds of claims, but we're not going to articulate exactly what that standard looks like. It involves partisan intent, that is, the desire of the legislature to entrench its partisan interests at the expense of others. It also has to have some kind of partisan effect. But the court said in 1986, and consistently since then, we don't require proportionality. That is, if you get 51% of the votes statewide, we don't require that being translated into 51% of the seats in the legislature. So we'll look at other things. And time again, when the court has been asked to reconsider this, the court has fractured, often badly, and refused to articulate a standard. Justice Kennedy, for a long time, was sort of the decisive vote in these matters, or should I say indecisive vote, because he recognized that the federal courts would remain open for business to hear these claims, but refused to articulate what the standards might look like. So last term, the Supreme Court took up a case from Wisconsin called Gill versus Whitford, in which a three-judge district court found that Wisconsin's state legislature had been excessively partisan gerrymandered in violation of the Constitution. And the court had the opportunity then to sort of establish a standard and chose to send it back on standing grounds. That is, they thought that the individuals challenging the map had failed to articulate that they'd been harmed in their particular districts. So as a sort of routine evidentiary matter, the case would be sent back. But this was Justice Kennedy's last term on the court. He left and was replaced by Justice Kavanaugh. And it's not clear what Justice Kavanaugh's views are, or actually the views of many others on the court who have joined since 2004, the last time the Supreme Court really took up this case in a serious way. So this term, the court has a pair of cases. One is called Rucho versus Common Cause. Another is called Benisek versus Lamone. One of them involves redistricting in North Carolina, where Republicans are alleged to have partisan gerrymandered themselves by drawing districts in such a way to ensure a 10-3 split in the congressional delegation. And in fact, there's evidence in the record where Republicans said, well, we want a 10-3 split, and the only reason we can't make it 11-2 is I don't think the geography will work. And then in Maryland, it was Democrats who gerrymandered the map for congressional district. They drew a 7-1 map where it advantaged 7 Democrats to 1 Republican, and the thought is that by shifting some individuals in and out of a district, they were able to take what had been a Republican district and turn it into a Democratic one. And so these cases are coming up before the Supreme Court ahead of the 2020 census. We're still relitigating these cases after the 2010 census, but the standards that the court comes up with, if it comes up with a standard, will understandably linger with us into the decades beyond this case. So there are 4 things, I think, that stood out from oral argument. The first is how much smoother this oral argument went, I think, than Gill v. Whitford. One problem last term is the standing issue really took up a lot of the bandwidth of the case. Another problem is that it was one case as opposed to 2, so the justices maybe were addressing some of their points in a bit more rapid-fire succession. So having a little bit more time to tease out these issues, and I think several of them were really struggling with how to articulate some of the standards. Both those inclined to find that the federal courts ought to be more involved in patrolling these gerrymanders, and others who thought that the federal courts really had no business, that this matter is best left to the political process. The second was that in addressing whether or not there's a partisan gerrymander, the court, and particularly Justice Kavanaugh, kept asking about the standard of proportionality. That is, despite the fact that the court had rejected this claim in 1986, Justice Kavanaugh and others kept suggesting, well, maybe this is inevitably what these claims really are about. They're requiring something close to proportionality. At one point he said maybe the Equal Protection Clause kind of requires this, that voters are roughly treated equally, and that looks something like proportionality. Now, this is a challenging claim because these cases have never really been litigated as proportionality claims. It's not clear if Justice Kavanaugh and others were just sort of playing devil's advocate or pressing back against the claims that if all these claims look at the end of the day like proportionality, they have to fail. But I think after oral argument, there were several individuals who got out in the media or blogged and said, well, proportionality doesn't make sense, it can't be the case, and so on. I think really trying to push back against the court's temptation to consider these cases as proportional. We live in a country where Democrats are more clustered together in urban areas and Republicans are more spread out in more suburban and rural areas. There's actually a natural geographic advantage that Republicans enjoy. And so we would expect that Republicans would typically gain more seats on the whole than the proportional voting would require when we draw single-member districts. That is, we're not just voting sort of in our state for Republicans or Democrats, we're voting within a single geographic area for an individual to go to Congress or to go to the state legislature. And so I think proportionality isn't the claim that's going to work. But the court spent a long time asking a lot of litigants about these questions. So I think proportionality is something to keep an eye on whenever the Supreme Court does come down with its decision. Third, it's worth noting that, a year actually makes a pretty big difference on the court, not just the replacement of Justice Kennedy with Justice Kavanaugh, but, last year, 4 states, Colorado and Utah and Missouri and Michigan, enacted by ballot initiative new sort of independent redistricting commissions that are going to change how redistricting occurs in the state. And for those in the court who were skeptical of judicial involvement in this area, they kept bringing up the fact that the states have been very active in this area. That is, voters by ballot initiative have been able to do so. Not all states have the ballot initiative, particularly eastern states, so it's not a one-size-fits-all solution. But for the justices who are reluctant for the court to be involved, this stands out as sort of one of the areas where in the last year, the political process has been willing to address the issue, even if the federal courts haven't. And finally, there's this sort of question about if the court does come down with a standard, what would that look like for next year? And Justice Kagan was, I think, the most vocal in noting that, at times some of this evidence is difficult to identify if you really intend to commit a partisan gerrymander, but you sort of haven't said so expressly. You have some pretty egregious statements in the record here from individuals, Democrats and Republicans, sort of expressing how proud they are about trying to entrench their political interests. But, by 2021, we would assume that those legislatures in the future and going forward would not make such overt claims in the record if the Supreme Court says that that's sort of evidence of a gerrymander such that federal courts might strike down the map. In the same way, if you don't make as egregious a partisan gerrymander, that is, if you drew a map that had 60 seats, which seems like a real outlier of the courts, but you instead drew a map that had 58 or 57 seats, whereas if the political scientists or the computer-drawn maps would typically be 54 or 55 seats, there might be a way that you've sort of insulated yourself, that you just can't gerrymander too far. And I think this is a question of if the court does come up with a standard that says the federal courts can patrol these issues, whether or not that will just drive underground or just narrow the range of opportunities for gerrymandering in the future. In short, there was a lot of open-ended discussion in the court, and I don't think that there was an obvious tilt from Justice Kavanaugh, from Justice Roberts, from some others in the court about how they might come down. So I think the court has been tempted for a long time to sort of figure out ways to avoid this question, to postpone deciding it. And to the extent that these cases are any sign of that, it's either going to really have to make the decision now to say these cases are just sort of closed off from the federal judiciary, send it back to state courts, the political process, or if it does come up with some kind of standard, to figure out one that's going to be generous and flexible enough such that the courts aren't constantly revisiting, revising every redistricting map throughout the country every 10 years.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.